Good afternoon, everyone. I will be playing the role of Mr. Shekhar Napare, who is the counsel for the petitioner when the actual hearings took place before the Honorable Supreme Court. So my main line of argument would be that Aruna Shaunbaug's right to life, which is guaranteed under Article 21, would also include a right to die with dignity. And I will be arguing in favor of passive euthanasia.
Secondly, Advocate Sukhpreet Grewal playing the role of counsel for the Union of India today.
Good afternoon, everyone. I'll be representing Union of India as the then Advocate General, Mr. Vahanvati, and we'll be discussing about why the petition is not supposed to be allowed, what will be the procedure if the euthanasia is to be allowed in our country. Thank you.
Thank you, ma'am. Thirdly, Advocate Eliza Gupta playing the role of amicus curiae, the major role in today's show.
Hello everyone, I'll be playing the role of amicus curiae. As you all know, amicus is the friend of the court, so I'm supposed to be a neutral person, and moreover, I'll be supporting the passive euthanasia and how a person is entitled to end his life because in any case, he's entitled to a dignified life. Thank you.
Advocate Mahir Sood playing the role of counsel for the KEM Hospital, Mumbai.
A very good afternoon to all the young members of the legal fraternity. I'll be playing the role of Mr. Pallav Sisodia, Senior Counsel, representing King Edward Memorial Hospital. Aruna Shaunbaug was taken care of for 37 years by the hospital, and I will be explicitly mentioning and contending that the petitioner has no locus. She is not the next best friend of Aruna Shaunbaug, and it is the hospital staff, nurses and the paramedics that are the main persons who are the friend. And the other arguments will be contentious on the other legal issues as well, which I'll be presenting. Thank you.
Thank you, sir. Lastly, Advocate Sahil Gupta playing the role of State of Maharashtra.
Good afternoon, everyone. I would be appearing on behalf of State of Maharashtra. I have been impleaded because Aruna Shanbaug was confined to a hospital which was situated in Maharashtra. So I'll be dealing with the Indian law as it stands today with regards to passive euthanasia. And if the Honorable Court is to allow the petition, what is the procedure that has to be established? I'll be also representing a team of board of doctors who were appointed by the Honorable Court to determine and assess the medical condition of Aruna Shaunbaug. Thank you.
Honorable Justice Meenakshi I. Mehta, ma'am, and Honorable Justice Talban Singh. Good afternoon, sir. Good afternoon, sir. Firstly, I will be briefing everyone about the famous case of Aruna Ramachandra Shaunbaug. My name is Abhishek Sharma, and today I, on behalf of Bar Council of Punjab and Haryana, hold this dais, and I am extremely overwhelmed to get this opportunity to address you all on this auspicious occasion organized by our elite institution. All the students will witness today the re-enactment of landmark judgment of Aruna Ramachandra Shaunbaug, and the real-time judges and lawyers will recreate the same atmosphere as it was then in the court by raising these same arguments, by giving it a modish vision of realizing the importance of relieving the earthling defunct because of the persistent vegetative state, that is, finally taking life deceased to wanted heaven as last wish. I would like to brief you on who Aruna Ramachandra Shaunbaug was and what were the events that led to the filing of this famous landmark case. Aruna Ramachandra Shaunbaug was an Indian nurse who was the center of attention in a court case on euthanasia after spending nearly 42 years in a vegetative state as a result of sexual assault. Aruna Shaunbaug was born in a Kannada Brahmin family in 1948. In Haldipur, Karnataka, she worked as a nurse at the King Edward Memorial Hospital in Mumbai. At the time of attack, she was engaged to a doctor employed at the same hospital. Miss Aruna was a staff nurse working at King Edward Memorial Hospital, Mumbai, and at the workplace, a sweeper tried to rape her, and when he found that she was on her cycle, he sodomized and left her strangulated. The next day, another sweeper from the same hospital found her in a pool of blood, and she was immediately hospitalized. The incident dates back to 27th November 1973, but when the case was brought before the Honorable Supreme Court, around 37 years had passed, leaving her in a pitiable health condition. Though she was abandoned by her family members, the nurses of KEM Hospital took good care of her. Later, Miss Pinky Virani, who claimed to be her next best friend, filed a writ of mandamus before the Honorable Supreme Court under Article 32 of the Indian Constitution to direct the respondents to stop feeding Aruna and let her pass on peacefully. Hence, euthanasia. Euthanasia literally translates into good death. Euthanasia, or synonymized as mercy killing, is a practice used to end prolonged anguish and pain. The court rejected the petition on 7th March 2011. However, in its landmark opinion, it allowed passive euthanasia in India. Later, Shaunbaug died of pneumonia on 18th May 2015 after being in a persistent vegetative state for nearly 42 years. Please. Now we will start this session. I would like to request all the counsels to come to the dais, and we'll start with the court is in session.
Please, my lords, do I have my lord's permission to commence arguments? I'm appearing for the petitioner in this case. My lord, I would want to start with a brief factual background of the matter at hand. Aruna Shaunbaug was a staff nurse, as my friend rightly pointed out, was a staff nurse at the King Edward Memorial Hospital in Mumbai. On 25th November 1973, a sweeper in the same hospital tried to rape her. Finding out that she had her menstrual cycle, he then proceeded to sodomize her after wrapping a dog chain around her neck. My lords, after that incident, the oxygen supply to Aruna's brain stopped. Because of that, she has been lying in a persistent vegetative state for the last 37 years. And I am, as her next friend before my lords, to plead that she be allowed to die with her dignity intact. My lord, I have come before my lords under Article 32, saying that the right to life guaranteed to all the citizens of India under the Constitution would also include the right to live with dignity, but also the right to die with dignity. My lord, I would like to rely on this Honorable Court's judgment in the case of Vikram Deo Singh Tomar, in which this Honorable Court had held that we live in an age when this court has demonstrated, while interpreting Article 21 of the Constitution, that every person is entitled to a quality of life consistent with his human personality. The right to live with human dignity is the fundamental right of every Indian citizen. My lords, I would like to point out what the condition of the petitioner is at the present moment, my lord. My lord, she has been lying on the same bed for the past more than 3 decades. She cannot move for fear of fracturing her bones. Her skin has become so thin, it is paper-like, and she has no cognitive abilities because the cortex of her brain was destroyed in the attack that left her bedridden and in a vegetative state, my lords. She cannot feel, she cannot see, she cannot respond. She has no reflex actions. She is merely existing. And my lords, this Honorable Court has held in a number of decisions that mere animal existence is no existence. every citizen has a right to live with dignity. My lord, in fact, Aruna's muscles are atrophied in such a way that even if she were to recover at this stage, she has no possibility of ever leading a normal life. My lord, I would further go on to say that I am here representing the petitioner Aruna Shaunbaug as her next friend. I have made several visits to the hospital to meet the petitioner. I have even, in fact, as a journalist, I have investigated the matter. I have written about her. I have written an entire book about her, and I am here to plead with my lords that the condition that Aruna Shanbaug lives in right now is no life as guaranteed by our constitution. My lord, further, I would like to say that even in the landmark judgment in Gyankor by this honorable court, this honorable court had relied on the judgment of the House of Lords in Airedale. My lord, if I could just read out some relevant paragraphs of that judgment of the House of Lords. My lord, the House of Lords in the case of Airedale, which was a similar case where the petitioner was in a persistent vegetative state, had held that in many cases, not only may the patient be in no condition to be able to say whether or not he consents to the relevant treatment or care, but also he may have given no prior indication of his wishes with regard to it. This is the situation in the present case as well, my lord. In the case of a child who is a ward of court, the court itself will decide whether medical treatment should be provided in the child's best interests, taking into account medical opinion. But the court cannot give its consent on behalf of an adult patient who is incapable of himself deciding whether or not to consent to treatment. I am of the opinion that there is nevertheless no absolute obligation upon the doctor who has the patient in his care to prolong his life, regardless of the circumstances. So all I'm saying, my lords, is that there is no absolute right to life where it does not constitute a right to dignified life, where the facts are such that the continued treatment would not serve any purpose for the benefit of the patient in question. My lords, in fact, I would further like to say that the Learned Law Commission of India, also in its 196th report, has already recommended the deletion of section 309. And in fact, the concept of voluntary death finds a very important place in our culture itself, my lord. There is also the prevalence of the Santhara ritual among the followers of the Jain religion, my lord, where it constitutes a fast unto death. It is almost a spiritual experience in that case, my lord, but in this case I am saying that the provision of passive euthanasia and the immediate stoppage of treatment and feeding to the petitioner would not constitute an offense under section 306 or 309 of the IPC, and it would in fact be a most merciful act that this honorable court would allow. With that, I rest my case. Please, my lord. In fact, I had referred to the Santhara ritual only as a way of showing that the right to die is also part of the right to live. It is a choice that an individual makes, my lord, but in a case like this, where the individual is not in a position to make that choice, whether to continue living or to die, my lord, I am saying that the decision should be made after taking into consideration what is the best interest. My lord, in a case like this, where she has not been able to get out of bed, where she has no way to express her emotions, where she has no cognitive abilities left, I am saying that it is in the paramount and best interest of the petitioner that she be allowed to die a dignified death. Please, madam. Please. Please. Please, my lord, because I am saying that euthanasia would not be the same as suicide. My lord, suicide is a choice that a person makes to end their life because of certain conditions, certain circumstances in their life. My lord, euthanasia would only be, I am pleading that euthanasia should be made possible only in cases where the person, it is in the best interest of the person to not continue living, where there is, where they have no possibility of recovery, where there is no possibility of them ever being able to lead a dignified and normal life, my lord. In that case, I am saying that this honorable court allow euthanasia, allow them to put a dignified end to their life.
What to do about abatement? Abatement will be always there. Once you, instigate or once you start this chain, okay, so how will you come out of the abatement part of it?
My lord, in that case, I would argue that the doctors who assist in ending the life of a patient like this who is in a persistent vegetative state should not be made liable for abatement, because it would be seen by the court. I am saying that this should be brought to the court. There should be sufficient checks and balances in place so that it is not misused, and the court should decide, after keeping in mind the opinion of the next friend of the doctors and the best interest of the patient in the matter, that this is a case where euthanasia should be allowed. And in that case, a case for abatement would not be made out, because this would not be a case for suicide, but a mercy killing, a dignified end to a life where there is no dignity left in continuing to live. Please, madam. I'm very grateful.
My lords, I'll be appearing for State of Maharashtra. My lords, I'll just broadly give my arguments on what I will be basing my arguments on. My lords, by the order dated 24th of January 2011, your lordships had directed to formulate a committee of 3 doctors in order to fully examine the condition that the petitioner is in. Lords, the team of able doctors, namely, my lords, J.V. Devatia, Dr. Roop Gursahani, and Dr. Nilesh Sahu was constituted. They had examined and assessed the condition of the petitioner in detail, and your lordship, I will be basing my arguments based on the report given by these 3 able doctors. If your lordships would turn to, my lords, page 4 of the judgment, lords, para 7, the report given by the doctors. Lords, I'll be broadly outlining what the condition of the petitioner is at the stage as it stands today before your lordships. Lords, broadly, the report held that the petitioner Aruna Shaunbaug is in no way in coma, or she is not even brain dead. She responds to music. She has preferences in her food. In fact, she smacks her lips when she is fed with chicken soup or fish. This can be, the doctors have gone and assessed the petitioner in detail, and they have assessed that the petitioner is in fact suffering from a disease called hypoxic brain injury. Lords, as per the report of the doctors, if a person suffering from the said brain injury does not recover after a period of 4 weeks, it is very unlikely that the petitioner will ever wake up. As per the report, as per all the patients suffering from hypoxic brain injury, the petitioner is amongst one of the longest survivors of such kind of brain injury. Lords, the other example which has been cited by the team of doctors is a case of one Mr. Terry Wallace in US. He had suffered with a similar brain injury caused by way of an accident, but he recovered after 24 years. He was in a permanent vegetative state for a period of 24 years, and after expiry of 24 years, he in fact regained some of the brain cells in his mind, and he is now living, he had lived a normal life after a period of 24 years from suffering the said injury. Now, my lords, the conclusion reached by the doctors is that although the care taken by, I'm sure my friend representing the KEM hospital would be elaborating on the fact, but my lords, I would like to place my appreciation on record with regards to the team of doctors and nurses which are constantly taking care of the petitioners. My lords, in fact, as stated by my learned friend from the petitioner's side, the petitioner does not even have a single bed sore on her body. And that is just a testament to the fact and the good care given by the dedicated team of nurses as well as doctors of the KEM hospital, which my friend is representing. Now, my lords, furthermore, I will be stating before your lordships the position of the Indian law as we stand today with regards to the dispute at hand. My lords, although there is a huge lacuna in our law, and there is no law which either regulates or which governs such situations where if a person is in a permanent vegetative state, what action has to be taken with regards to the said patient. My lords, with regards to Indian law, as per section 2D of the Transplantation of Human Organs Act 1994, the brain death has been defined. As per section 2D, brain death means the stage at which all functions of the brain stem have permanently and irreversibly ceased, and so certified under subsection 6 of section 3. My lords, even as per the Indian law as we stand today, the petitioner cannot be characterized as someone who is brain dead. This is the position that we stand today. Now, my lords, this act further talks about when the brain, if a person is brain dead, can be transplanted. Now, my lords, with the advancement in the field of medicine, a person is not declared dead only when he stops breathing, but when his brain cell, but when he suffers a brain death, or in medical terms it is known as brain stem death. The petitioner cannot be characterized as someone who is brain dead. So, my lords, as per the position of the Indian law we stand today, the petitioner can in no way be described as a person who is dead. Lords, furthermore, this issue, my lords, for the first time has cropped up before this honorable court in the case of Lords P. Ratnam versus State of Kerala. In that case, my lords, your lordships had observed, lords, in fact, it is a judgment, in my humble opinion, way ahead of its time. In fact, that judgment strikes down section 309 as well as section 306. But, my lords, I will be failing in my duty to express that this judgment was in fact subsequently set aside in the case of Jan Kaur versus State of Punjab. Lords, even in the case of Jan Kaur, your lordships, as it was then, have delved into the question as to what has to be done with the patients who are suffering with the condition that the petitioner is suffering till date. Lords, even in that case, your lordship had read that if at all your lordship comes to a conclusion that the life support has to be withdrawn from the petitioner, it would not fall into the category of either 306 or 309. For a simple reason, because the person who is living, it was held by the Honorable Constitution Bench in the case of Jan Kaur, that a person having right to life must also have a right to die in dignity. Now, this is a complicated question before your lordships today, whether if your lordship decide that the petition has to be allowed, since there is a huge lacuna in the legislature part, your lordship would have to be delving upon the procedure as to what has to be followed when it comes to dealing with cases at present, lords. Lords, I would also be suggesting some steps which your lordships can take if your lordship were to decide to allow the said writ petition. My lords, as per section 226 of our Indian Constitution, the high courts, the respective high courts are very well in their jurisdiction to pass any writ of mandamus and to direct the team of doctors if they approach the Honorable High Court with regards to pulling off the life support system from a person suffering from PVS. Now, my lords, what procedure has to be followed, and there are certain safeguards that your lordship would have to be examining in case your lordship were to decide to allow this writ petition. My lords, if let's say a writ petition is filed before the High Court seeking a writ of mandamus to withdraw the life support system from a person suffering from a permanent vegetative state. The High Court can delve into the question. Notices can be issued to the general public, the next of kin, either a spouse or a sister or a brother or a friend or any of the next kin, as well as a local counsel can also be appointed by the Honorable High Court to examine and to assess the exact position that the patient is suffering in order to come to a better conclusion with regards to the health as well as to the condition which the patient is in at the time the Honorable Court is being approached. My Lords, as far as the state of Maharashtra is concerned, I am only playing, Lords, in fact, I would only be suggesting that if your Lordship were to allow this writ petition, your Lordship has to take care that such practices, because in India, the situation cannot be ruled out wherein these conditions can, where these aspects can be misused. There can be some mischiefs or unscrupulous practices by the relatives or by other persons in order to grab the property and to inherit the property. That is the question that your Lordship will have to decide. And Lords, in my capacity as representing the team of doctors, I would once again like to place my appreciation for the team of doctors and nurses of the KEM hospital. I would be resting my submission, Lords, on this aspect. If your Lordship has any question, Lords, I will be great.
What do you have to say about the locus of the journalists who have come to court?
My Lords, with regards to the locus, Lords, Lords, since the team of doctors have been examining the petitioner in detail, Lords, my argument would be the locus would only lie with either the team of doctors or the nurses who have been taking care of the petitioner for the past 37 years. The petitioner, Lords, cannot be held to have locus standi in the present case as she is not even the next of kin. As per her own arguments, she has only been visiting her for some time. She might have written a book, but the nurses and the team of doctors who are taking care of the petitioner for the past 37 years, in absence of any family member or the next of kin, my Lords, in my humble opinion, the doctors and the nurses would have the locus standi in this case, and not the petitioner. Great.
I am appearing on behalf of Union of India. And your Lordship, my submissions are that the petitioner in the present case does not have the locus standi to file the present petition. The first contention is, your Lordship, that she is a journalist. No doubt, I respect my colleague for her affection for the victim in the present case and for her consideration. But your Lordship, she is not her next best friend. In the present case, after the Aruna has suffered from such a tragic incident, she was abandoned by her parents, by her fiancé. It was the hospital who has taken care of her for the last 36 years. Her medical report shows that there was no negligence on the part of the hospital. No doubt the present petitioner has visited the hospital few times, but that does not give her a right to file the present petition in the first place. Then, your Lordship, because the petitioner in the present case, she is not a doctor. She does not holds that qualification that she can give a statement about the condition of the victim in the present case. Because as per the science, the victim is in previous, that is in a permanent vegetative state. But your Lordship, the petitioner has stated that she is suffering, she is in pain. But as per the medical report, she does not have emotions at all. She does not know happiness, she does not know sorrow. So it is not us who can decide what she is going through. We do not know what she lives in her own world. As per the doctor's opinion, she is equal as a child born with cerebral palsy. This condition is when your brain has not fully developed. That doesn't give us the right to decide upon whether the life of the petitioner in the present, life of the victim in the present case should end. We believe, we as a country, we are a country which holds our moral values and culture above all. We are the country who love to take care of our elder parents as well. We cannot allow anyone, any particular person to decide about the life of the of any victim, because then, Your Lordship, no doubt we are a great nation, but the law can be misused. This particular law, if it gets decided in the present petition, it can be misused by various ways. Might be because of the greed, or might be just to obtain inheritance. Then the parents, or might be the next best friend, or might be doctors can also collaborate in that. It should always, before this honorable court to decide whether a decision about the euthanasia should be passed or not. Otherwise, Your Lordship, at present in India, we do not have a law that covers the euthanasia part. Though passive euthanasia do happens when every day in hospitals where they withdraw the life support system. But this is not a case where the victim is relying on the artificial life support. She is otherwise her brain stem is alive. She is not brain dead, so we cannot say that she is dead. It is not that on the artificial life support she is surviving. And Your Lordship, kindly see the KEM hospital. For them, this case is not just about the life of the victim. This present case covers the bigger picture, because the medical ethics also comes in the picture. What kind of message it's gonna send towards the hospital who has taken care of the victim for the last 36 years, and also the society. Because if we allow the present petitioner, then we will be sending a message that a child who is born with, whose brain has not developed fully, we are giving a right to the parents also to end his life, but that is not so. That is on humanity grounds also, that is not going to be a good law if we see. Then Your Lordship, kindly see the petitioner who has gone to visit the victim. Sometimes we also hold that perception that the underprivileged children, or might be the less fortune, or the victim, we always see them as a victim, not as a person. We do not have the right to see that they are the less fortunate ones. We do not have the right to see that we can make a decision about their life. It's their life. Might be they are living in their own life. Might be their brain is not functioning fully, but they have their own world. She is breathing on her own. She is having her food. She, no doubt, but I believe that the present petitioner should not be allowed. And Your Lordship, kindly see, in Gyanpa's case, the Honorable Supreme Court already has held that the right to death is not covered under Article 21. Your Lordship, kindly have the page number 97, para number 97, page number 42 of the judgment. It also discusses the law at present in India. Your Lordship, even the section 306 is a crime in our law. At present, an attempt to commit suicide is a crime. How can we allow a person to take a decision about the life of the victim? Even if it's a doctor, even if it's the parents, we cannot say that they have the right to decide. Because if she was on an artificial life support, then yes, might be this could have been allowed, but not in the present case. Because this will send a very wrong message to the society as well. If a child is born with that kind of condition, we will be sending a message that the parents will be having the right to end that child's life. And Your Lordship, in future we never know, if we rely on the science, then might be in future we can find a solution for the state of the present victim. Might be we'll be able to get a treatment in future. Please, Your Lordship, that will be all.
So what is your prayer to the court? What exactly you want?
Your Lordship, my prayer will be kindly dismiss the present petition, Your Lordship.
You want her to live and the natural life and
Please,
wait for the natural
the
life.
victim should meet her natural ends. Great.
Please, my lords. Lordships, I am appearing before this honorable bench with regard to the KEM Hospital, Mumbai, which is the King Edward Memorial Hospital, Mumbai. While issuing notice of motion, this honorable bench on 16th of December 2009 issued notice only considering the critical condition of the petitioner, namely Aruna Shaunbaug, and to espouse the correct legal position of law with regard to the untouched stone of euthanasia, especially in the light of the 1996 judgment of the Niyam Court. Thereafter, Lordships, the counter affidavit was filed upon issuance of notice by Dr. Amar Ramaji Pazare, who is the professor and head of the KEM hospital. And in this, he has submitted that Aruna makes sound when she has to pass stool and urine, and she, while which the nursing staff identifies, she attends, she eats, she is also responding in normal course, eating food, responds by facial expressions. To which this Honorable Court passed the order that since there are some variances between the allegations in the writ petition and the counter affidavit of Dr. Hazare, this court was pleased to constitute a medical board. Subsequently, once the board was constituted, the first examination which took place on 24th of January 2011 by the able assistance of 3 orders by the kind order of this court, the examination took place on 28th of January. And second examination on 3rd of February. And in both the examinations, with regard to the medical report, with the kind permission of this court, may I just read out 2-3 lines for the assistance of this court? Lordships, in the medical history, it has been come in the para 4. With Lordship's permissions, may I read? The hospital staff has provided her an excellent nursing care since then, which includes feeding her by mouth, bathing her, and taking care of her toilet needs. The care was such an exceptional nature that she has not developed a single bed sore or fracture in spite of her being bedridden since 1973, Lordships. Now, my humble submission is, it has been 37 years, no single instance of bed sore in the history of the medical jurisprudence and science. This can be appreciated as an impeccable service towards a patient, which is namely Aruna Shaunbaug. And yet there has not been a single case that person has been so far for so long time been without bed sores, especially in our country. This talks volumes about the love and affection of the hospital staff, nurses and the worthy paramedicals with regard to the care and precautions for the patient Aruna Shaunbaug. Well, we appreciate the concern of Ms. Virani, and the learned senior counsel has zealously contended with regard to the locus, and we hold Ms. Virani in the highest esteem, but she can nowhere be near the next friend of the petitioner. At least it is our submission that KEM hospital stands at a better footing. With Lordship's permission, may I just read out the affidavit of Dr. Sanjay Oak, who was the main person who, in charge with regard to the hospital where the care of the person in question is taking place. So, I'll just read out, Lordships. It would be incorrect to say that Aruna Shaunbaug is an appropriate case for coma. It appears that for crucial critical period, her brain was deprived of oxygen supply, and this has resulted in her present state similar to that of cerebral palsy in a newborn child. It is a coordination between brain loses its coordinatory, sensory as well as motor functions, and this includes the loss of speech and perception. This has resulted into a state which, in a layman's words, Aruna lives in her own world for the last 37 years. This we are fairly admitting, but skipping to the relevant part, he says that her eyes are open and she blinks frequently. However, these movements are not pertaining to specific purpose or a response in question. At times, she is quiet, and at times she shouts, oblivious to anybody's presence in her room. It is not true she shouts after seeing a man. I do not think Aruna has distinguished between a man and a woman, nor she can distinguish between ordinate and inordinate object. We play devotional songs rendered by Sadhguru so-and-so in her room, and she lies down on her bed listening to them. She expresses her displeasure by grimaces and shouts if tape recorder is switched off. All these years she was never fed by tube, and whenever the nurse used to take food to her lips, she used to swallow it. It is only since September 2010 she developed malaria and her oral intake developed. In order to take care of her calorie need, nurses cadre resorted to nasogastric tube feed, and now she is used to NG feeding. However, if small morsels are held near her lips, Aruna accepts them gladly. It appears that she relishes fish and occasionally smiles when she is given non-vegetarian food. However, I am honest in admitting that her smiles are not purposeful, and it would be improper to interpret them as a signal of gratification. I must put on record that in the world of the history of medicine, there would not be another single case where such a person is cared and nurtured in the bed for 33 long years and has not developed a single bed sore. I apologize. Then he again says, with Lordship permission, may I further read? The very idea of withholding food or putting her to sleep by active medication, mercy killing, is extremely difficult for anybody working in, say, GSMC and KM hospital to accept, and I sincerely make a plea to the learned counsel and honorable judges of the Supreme Court of India that this should not be allowed. Aruna has probably crossed 60 years of life and would one day meet her natural end. The doctors, nurses and staff at KEM are determined to take care of her till her last breath by natural process. Often, Lordships, we have seen, we live in the Indian society where parents are also considered as the godly figures. But there are some persons who are left at the virtue of the society. The KEM hospital has utmost regard, and my friend from the petitioner side talked about dignity. Aruna is living a dignified life under the able care and administration of the hospital. With regard to this, which brings me to the next question, which I ask myself and I ask the society as well. It is with regard to the medical report. Can we say that the Aruna Shaunbaug can be she considered a brain dead? She is smiling. She is listening to devotional music. She believes in the God Almighty. She is also responding to the presence or absence of somebody. We cannot call her brain dead. And this is what has been admitted in the medical report as well. With Lordship's permission, may I just point out one issue with regard to the medical ethics which comes into play in such scenario for the assistance of this court.
Yeah.
Since Lordships, I am representing a hospital, there are twofold principles with regard to the medical ethics. First is the consent. Second is the beneficence. With regard to the consent, my friend claiming to be the next best friend of Aruna Shaunbaug is disputing that her consent is no consent, but the consent as such of the person who is in a difficult medical situation also, it has to be seen who is the person with the best interest. Our stance is clear from day one that KEM hospitalist staff, nurses and paramedics are duty bound and committed to serve at the pleasure of Aruna Shaunbaug. Therefore, the question of when consent comes, we are disputing the locus, that my friend's consent will be no consent with regard to petitioners. With regard to the beneficence, Lordships, I must say that the beneficence is an act what is or judged to be in patient's best interest. When the hospital is taking care and the staff is taking care, again the second principle goes in the favor of Aruna through KEM hospital. The third aspect, Lordships, we think that she should die naturally, and not only that, we say that euthanasia is an untouched stone before this honorable bench, being the torch bearers, to settle the legal position. But this bench may think about the situations where suppose what can be the misuse of euthanasia. Suppose some person is old and some greed comes into play. The children want their parents to be eliminated. I am using a very heavy word before this honorable court. What in those situations? We live in a society where there must be checks and balances, and there must be a situation where at least, even if this law is to be allowed and it is to be permitted. We are not advocating for active euthanasia, passive euthanasia. Even in those situations, this Honorable Court may consider for extreme intricacies of checks and balances that it is not misused. That is one kind submission from the Council to this Honorable Court. Second of all, Lordships, with regard to the issue of Gyan Kaur case, which my friends have touched upon, that the issue of right to life is there covered under Article 21. One has the right to die with dignity as well. But who are we to decide what is dignity for Aruna Shaunbaug when the Pinky Virani herself has met her only couple of times, couple of years. She can nowhere be close. When I have personally visited the hospital, done my due diligence as an officer of the court, and I can say with utmost proudness that the hospital staff has developed extreme intricacies of care for her, and the locus does not stand in this case.
I would like to ask if there is any chance for improvement in her health condition as per the expert's opinion.
Please, Lordships. Lordships, as per the medical report on record, the state is said to be irreversible. But we live in a world of hope, and the medical science is developing, and medical science itself is a form of evolution. Who knows, maybe tomorrow we come up with some cure for her state as well. The mankind has developed from caves to we are living in valuable homes, and this is the development we can always be hopeful about.
One more question.
Please, Lordships.
We have heard about kidney transplants, heart transplants, liver transplants. Does medical history have something like brain transplant?
Lordships, at this stage there is no such provision for transplantation of brain, but we are hoping that
Is it medically possible?
Lordships, not to the best of my knowledge and as per my best of instructions, it is not possible. But maybe Union of India can assist further on this subject, being representing the Ministry of Health also collectively.
Madam, may I make a very small submission like what my friend has just said? My lord had posed a question whether the condition of the petitioner is irreversible or not. My lord, in fact, as per the reports of the doctors, it is irreversible. And even if we say that there is some hope, some little 1% hope that the petitioner could recover, my lord, even in that case, even as per the reports of the doctors, she is in no state where she will even be able to get out of bed, my lord. As soon as she tries to move her hands or feet, any of her limbs, there is danger of immediate fracture of all her major bones, my lord. In fact, her muscles have also atrophied, so there is no possibility of any sort of movement, even in case there is a miracle and the petitioner is able to recover, my lord. That is my short submission to what my learned friend just said. Very briefly.
With this, Lordships, may I just make last submission? Your Lordships may kindly consider the present matter encompasses both legal and emotional issues. And even though law says we must not be driven by emotions, but in this case, I submit that it is my duty to submit as officer of the court that the emotional aspect of the nurses, staff and paramedics may be kept into as one of the consideration by this court while adjudicating the entire issue at hand. And with this I rest my arguments. Yeah.
But again, I'll resubmit my earlier submission that she is not a doctor. She cannot say about her medical condition. Right now, she is alive. If she has suffered a lot already, if we are going to restrict the diet, she is going to suffer more pain out of hunger. That is how the human body will function. We are going to make her suffer more. Though she cannot experience the emotions at present, but at least her body needs to be met. We cannot say that we are going to keep the victim hungry so that she can die. That is going to be very inhumane. And Your Lordship, the otherwise also in the present case, there I would like to discuss the doctrine of parens patriae. That is the state. It tells, Your Lordship, kindly allow me to read the para number 128 at page number 48. The doctrine of parens patriae, father of the country, had originated in British law as early as the 13th century. It implies that the king is the father of the country and is under obligation to look after the interest of those who are unable to look after themselves. The idea behind parens patriae is that if a citizen is in need of someone who can act as a parent, who can make decisions and take some other action, sometimes the state is best qualified to take that role. At present, we are not in the British era. There is no crown, but the state is the ultimate father who needs to take care of the underprivileged. In this case, we do not have that right. The petitioner does not have that right to say that the victim, she is incompetent. And the petitioner has the right to decide whether we need to end her life or not. We should not make her suffer more. Grateful.
First of all, I would express my thanks, my gratitude to the bench for considering me worthy to be appointed as amicus in such a matter. My lords, first thing I would like to address is the locus of the petition. As a friend of the court, as amicus, I am supposed to take a neutral view so that the bench could reach a correct and just decision. My lords, I agree the job done by the hospital staff is commendable, is appreciable. They have done restless and selfless service. But at the same moment, one point which nobody can disagree is that for past 37 years, she's been in the same state, same vegetative state. She's not able to move. A human, how he becomes a human? Because of his behavior, his interaction with co-humans, she's not able to do that. So any human who has a human behavior, who has human emotions, would feel that they will be moved by this situation, and that's what has happened to the petitioner here, Pinky Brown, who claims herself to be a next friend of the petitioner. So in any case, we cannot question her humanitarian intention, although I would agree that yes, hospital staff is a better placed person to be the next friend of the petitioner. Now, my lords, we have been using certain terminologies which have been repeatedly used. So I would like to bring the kind attention of my lords to the definitions and what those medical terms and other definitions would mean. First of all, my lords, euthanasia. What does euthanasia mean? Euthanasia means when you are killing somebody or you are allowing somebody to die by not supporting them, as in I would say life supporting system, ventilator systems, or any kind of support system like you are feeding them through nasogastric tubes or any other kind of life support system. So that results only on account of the person suffering from irreversible stages, incurable diseases, or we can feel that this person cannot be considered to be alive. That is euthanasia. Now there are two perspectives to euthanasia. One is active euthanasia, another one is passive euthanasia. Of course, I am not in favor of active euthanasia because in this we take a positive step whereby we are inducing some poisonous, some mechanical to end that person's life. However, the passive euthanasia here we are considering is when we allow that person my apologies, ma'am. So, passive euthanasia would mean when we are not taking steps to support the life of that person. Like if he has to be on ventilator, 100% oxygen support for 24/7, then we remove
remove that option from the court. If he is to be feeded artificially through nasogastric tube, we remove it that way. We are not feeding him. That is what passive euthanasia means. Anybody who cannot feed himself, anybody who cannot breathe by himself, how can we, extend their life by just artificially supporting them? That is not a dignified life. As my friend, counsel for the petitioner, I truly pointed out, life is not just life. It is dignified life. It is life which you are able to live as a human. With that, I will move on to the other definitions, like brain death. What basically is brain death? Initially, death was referred to as only when you stop breathing. Now, with advancement of science, we have certain more parameters to death. If we consider brain death means a person, though is breathing, his blood circulation is there, but he is not able to behave in that way where he is a human. Secondly, he has no voluntary movements. He cannot move his legs. He cannot walk around. He cannot have interaction with more people. That is what brain death means. Now, if we come to the condition of the present petitioner, Aruna Shaunbaug, she is considered to be in a vegetative state. That would mean that her breathing is there. She is able to eat food. She is able to breathe. She is able to do her natural activities, but at the same time, she is in a vegetative state because she is not anymore having a human behavior to say that she cannot interact with others. She cannot move around by herself. She has to be treated. She cannot eat by herself. She cannot do what a normal human would do. If my lords may have page 14, there are certain behaviors which fall under vegetative state. If these behaviors are there, so the person is considered to be in vegetative state. However, he is not brain dead. At the bottom, my lord would see there are pointers. Sleep-wake cycle with eyes closed and then open. That means the person can open his eyes and close his eyes. Patient breathes her own. Spontaneous blinking and roving eye movements, producing sound but no words. Brief, unsustained visual pursuit. Remembering the pain, changing facial expressions, yawning, chewing jaw movements, swallowing her own spit, non-purposeful limb movement, arcing of the back, reflex withdrawal. So if brief movements of head or eyes towards sound and movement will start to do a loud sound. However, if we see all these points, they are there in the petition of Aruna Shanbaug. However, she cannot do all this by herself. She cannot do all those tracks that she cannot feed herself. She cannot move around. She cannot interact with the community. She cannot recognize people. So that is nowhere can be considered as a human behavior. Next, my lords, I would like to refer to certain jurisprudence in other countries, how they have dealing with this matter. First of all, I would like to bring to the notice of my lords is the law of England, that is Mental Capacity Act of 2005, whereby it has been recently enacted and whereby the laws of England have recognized the persons who are incapable to take decisions on their behalf. However, in their best interest, a court-appointed or a mixed friend can take the best decisions for them because they are themselves not able to consent to what is best for them. This act also can be, we can say that this is applicable to tracks of the present case because the petitioner is in such condition that she cannot take decisions for herself. So if the next friend or the counsels of she cannot recover and she cannot take decisions for herself, then of course in humanitarian grounds on seeing her conditions and nobody would disagree on that it is an irreversible condition as of now. And she has been in that condition for 37 years. 37 years is a long time, my lords. For that, we have to consider on humanitarian grounds that a next friend or whosoever may be the next friend should be able to take the decision on her behalf. like for the minors we consider that they are not appropriate to take, or they do not have that mental understanding to take that decision for themselves. So we give their guardians or their next friend a right to take decision on their behalf. So similarly, I would say that a next friend or a person who is concerned about that person should be able to take decision to give consent on their behalf. Now, my lords, I would like to refer to the laws of Netherlands. If my lords may have page number 26. Netherlands itself has a regulation which says termination of life on request and assisted suicide Act of 2002. There in Netherlands, that is a country which recognizes euthanasia. Now this concept was deeply covered under Postma case there, and on that account they have come up with certain pointers that how passive euthanasia can be used to give a person a dignified death. I would use that word, dignified death, because of course if we say that I have right to live, I would say I have the right to die also, to have a dignified death. I cannot die like a human being, just I die and there's nobody there. Now in Netherlands, the law allows medical review board to suspend prosecution of doctors who perform euthanasia when each of the following conditions is fulfilled. Now they have laid down certain conditions, and if the doctors are within those conditions, those parameters, they are not liable for what they have done. The patient's suffering is unbearable with no prospects of improvement, similar to the case in the petitioners. The patient's request for euthanasia must be voluntary and persist over time. The patient must be fully aware of his or her condition, prospects and options. There must be consultation with at least one other independent doctor who needs to confirm the conditions mentioned above. The death must be carried out in a medical appropriate fashion by the doctor or patient, in which case the doctor must be present. So with these checks and balances, Netherlands has adopted that person can have a dignified death. A person who does not have the scope of revival, who does not have the scope of living a human life, can be put to death. Similarly are the laws in Switzerland. In Switzerland, there is a distinction drawn between two concepts. One is the euthanasia, other one is assisted suicide. In euthanasia, the person is administered, in assisted suicide, you are assisting the doctors or the person considering is assisting the person's death. They are inducing some kind of poisonous substance that would be equivalent to active euthanasia, I would say. And in later, the euthanasia, the doctors or the person who are taking care of those persons, they come to a decision that you need to stop this person's support to assist his life, to live him, to make him live. Similarly, in Belgium also, I would like to bring to my notice that in Belgium also, there is a practice of euthanasia. However, I would fairly submit that in other countries, there are no such parameters of having euthanasia as a legal thing. Because of course, as respondents have also pointed out, that there are pros and cons of everything. There are chances of misuse also. So we can always apprehend that. But then, my lords, we are here, so we can have checks and balances. We can decide upon how we can go ahead with passive euthanasia. So, my lords, in this case, I would put forward that we can, with certain checks and balances, we can have passive euthanasia, so that as a human we can allow that person to have a dignified death and a dignified death. With this, I would rest my case. Well, Lucas, as I already pointed out, that we cannot give away the condition mentioned that she is in vegetative state for past 37 years. Any human who will see that person in a vegetative state, his conscious would stop. He would be emotionally unstable. So that is the reason I will say that even if she does not have the person, she has all, as a human, she has the right to bring to the point that this person is suffering so much, and we as a responsible citizen of the court, as officers of court, we have to bring to the knowledge of the things which are happening in the society and which are good for the society. So that's how I would say that we should not take it negatively.
I request all of you to be seated, please. In a court trial, you're not supposed to keep doing that. Please be seated, all of you. Please maintain decorum of the court. Please, Your Lordship, may I? Your Lordship, kindly see, I do not agree with my learned friend here. Because we cannot downgrade a human, a person, just by saying that if a person is not able to walk or talk, or either he is deaf or not, or whether he is able to have his food by his own hands, then only we can consider him as a human being. If a person is without legs and arms, if a person who is deaf, we cannot say that he doesn't have a right to life. And Your Lordship, kindly see that in India, the law can be misused at a very bigger scale. No doubt we have a culture that we would like to take care of everyone. But there are people who misuse the law every day. As per the recent data, 84% of the rape cases are found to be false. If the law in the euthanasia is passed in the present petition, who is going to take that guarantee that it will not be misused by human beings or the doctors in future? Because in our country, the data when it comes to misuse of the law, it is a huge percentage that we cannot say. And Your Lordship, kindly see, please, I apologize. I rest my case, Your Lordship. This petition may kindly be dismissed. We should not pass a law allowing the euthanasia. Grateful.
I would only want to make a one-line submission in reply to what my learned friend from the Union of India has just submitted. Misuse of laws, my lord. Lord, I'm only saying that just because there is an opportunity for misuse a certain provision of the law or a certain precedent of the law, it does not mean that we take away the fundamental rights of others who actually are in need of that decision of that law. This would be true for everything from dowry, from rape legislation, everything that relates to women, crime against other sections of the society, my lord. Misuse cannot be the sole ground for denying rights, denying fundamental rights, denying right to identity. Will mention.
Euthanasia is one of the most perplexing issues which the courts and legislatures all over the world are facing today. This court, in this case, is facing the same issue, and we feel like a ship in an uncharted sea, seeking some guidance by the light thrown by the legislations and judicial pronouncements of foreign countries, as well as the submissions of learned counsel to us. The case before us is a writ petition under Article 32 of the Constitution and has been filed on behalf of the petitioner named Aruna Shaunbaug by one Miss Pinky Virani of Mumbai, claiming herself to be the next one. We could have dismissed this petition on the short ground that under Article 32 of the Constitution of India, the petitioner has to prove violation of a fundamental right. And it has been held by the Constitution Bench decision of this court in Haryana versus State of Punjab that the right of life guaranteed by Article 21 of the Constitution does not include the right to die. Hence, the petitioner has not shown violation of any of her fundamental rights. However, in view of the importance of the issues involved, we decide to go deeper into the merits of the case.
I would like to thank all of you for the patience and hard work that you're kind of doing in sitting here. It is very difficult for you students to sit for, I think, 2 hours also. This case in the courts took 2 years for the trial to reach a conclusion, and it took 42 years for Aruna Shaunbaug to just die without justice. And for 2 hours, you guys are not able to sit patiently. This career, the first demand is patience. The first thing that you have to learn is the law of waiting, other than any other law is. So I would request that you please be seated, because also I feel immense gratitude and pleasure in announcing that we have Ma'am Anu Chatrat with us. She's a senior advocate at the Punjab and Haryana High Court. She's also the Dean of Faculty of Laws across all the colleges and the Punjab University. And she has served as a mayor of the City Beautiful in 2005 and 2010. I would like ma'am to come and please enlighten us with the kind words. Please be seated. And the seminar or the session is still about 15-20 minutes to go. Please show some patience and gratitude towards the court who is here for your enlightenment. They know everything. It is for your benefit.
Good evening. Honorable Mrs. Justice Meenakshi Mehta, the Judge of the Punjab and Haryana High Court. Honorable Mr. Justice Talwant Singh, Judge, Honorable Delhi High Court. My colleagues from the High Court and the Faculty of Laws. Mr. Suvir Sidhu, the Chairman of the Bar Council, I can address him as a dynamic leader because he has been always motivating and encouraging the youngsters. My young fellow colleagues who have helped in depicting the exact scenario of the court while delivering the judgment under the able guidance and help of the Honorable sitting judges of the Honorable High Court, because as a former Dean of the Law Faculty of the Punjab University and as a senior advocate, because now the young students are sitting, I would like to share only one experience which I have learned during my 30 years standing at the bar. Because when I joined this noble profession in the year 1989, joined the law course, professional course, at that time the girls were very few in this profession. And because we are 3 sisters, because I am sharing with these things with you to encourage the young girl students. We are 3 sisters, and many persons at that time, they used to say that this profession is not good for the girls. My father, who was a senior advocate and a Advocate General of Punjab, he took a stand that I have 3 daughters, I have well-established library and such a long standing at the bar, someone from my family has to win this profession. So I joined with this motivation, I joined this course in the year 1989 and completed in 1992. Then normally in our past days, the custom used to be that yes, we must think about the marriage of the girls, daughters. At that time also, my father took a stand that girls have to be professionally and financially independent. I got married in 99. After 7 years long standing at the bar, And now I can share that I am happy to see this gathering in the hall that more than 50% are the girl students. So this is an encouraging factor for all of us. And when we did the law, there was one compulsory moot competition, and that too before the faculty member, professors. And as a students, normally we were not having so much as we are getting the opportunity now under the able guidance and with the help of the Bar Council of Punjab and Haryana and over legal institutions. And happy because now our sitting judges are very willing to come, address the students, spare their time and while encouraging the young students. This is a great opportunity and we must take benefit of this opportunity. We must participate in the moot competitions. We must be very alert, and the students who have been busy during this picture presented by my young colleagues, having selfies and chatting on the phones, they must at least in future, they must take a decision that we must take benefit of each and every opportunity, because I have personally seen the students, they have been working day and night for the last 15 days to present this true picture before you, before the actual courtroom picture under the able guidance of sitting judges. And because as a dean, I have seen many students, because we used to hesitate to present the moot competition or participate in the moot competition before a faculty member. Now the youngsters are appearing, participating before 5 sitting judges of the Hon'ble and Supreme Court judges. So the day we join this noble profession after participation and after completion of our degree, we can appear first in the court. Otherwise, we will be wasting over 1 or 2 years under the seniors and learning the things which we should have availed and learnt at the time of during our student life. So we must take benefit of. And the main thing I would like to share with you is that we should never shy, after joining the profession, we should never shy away from the hard work. Second is, networking is a must to grow in this profession. Third is, courtroom is less of facts and more of communication skills. So the way you present your case is all that makes the difference. Fourth, never deviate from your loyalty towards your client. And the fifth important thing which I have seen, never intentionally make a wrong statement before the honorable judge, because it is better to lose a case than losing a judge. Because once you build up this reputation that he has intentionally misstated some facts or intentionally tried to mislead this honorable court, that really affects our future. And now I congratulate especially the Bar Council for organizing this special event for the young student, as is clear from the theme of the topic, that their main effort is to encourage the young students to the day they join the profession, they are in a better position to address the honorable judges and start earning first day instead of spending 1 or 2 years in learning. So I congratulate the entire team who have really worked day and night making this event a great success, and congratulate especially the Bar Council under able guidance of Mr. Suvir Sidhu and his entire team. I congratulate the organizers because 2 events we have seen, it is a great success. So congratulations to the entire organizing team, and special thanks to the students. It is very difficult to spend so much time, but whenever you are getting a time to learn something, you must avail it. Thank you very much.
Thank you for the kind words, ma'am. And she rightly said that females should come ahead and do this. I see a lot of female students here. Our 60% members of the bar were female and 50% of the bench is female. So thank you, ma'am, for your kind words. Now I'd like to invite Justice Talwant Singh to say a few kind words to enlighten young minds.
Meenakshi Mehta, Mr. Mehta in the audience, and dear friends. I think it gave us, it gave me an opportunity to be with you. And of course, the case has got more emotional content than the legal content, I would rather say. And but the bench at that time, maybe 15 or 20 years ago, they came up with a judgment. It's quite a balanced judgment. The reenactment, you have to judge whether it was perfect or not. We can't judge because we are the actors in it. So you have to judge and see whether it was perfect or not. My advice to all of you: take a call whether you want to be a lawyer or you don't. You want to be a litigation lawyer or you don't. If you want to be a litigation lawyer, you have to wait in court for hours together. Okay, and mobile phones are not allowed in courts. You can't just sit down and play on your mobile phone. A lawyer generally spends 5 to 10 minutes in a day in a case arguing the matter. The rest of the day only he has to wait for his turn. So develop that patience, as the earlier speaker has told you. If you have that patience, only then you can be a litigation lawyer. Similarly, when a client comes to you, you have to listen to him. And the clients, once they start, they'll take hours to narrate their story. You have to pick up the points from their story, which points are relevant for the case or not. And there also, your 100% attention has to be towards your client. Litigation is a fantastic profession. There are people who will be going for jobs. There will be people who are going for solicitor firms. Of course, they can take their chances. But the few of you, or say more of you who wants to be there on the litigation side, you have to work very, very, very hard. Just develop that practice during these 5 years. We used to get 3, you got 2 more. So you know which direction you want to go. Attend more moot courts. Try to go and attend the regular courts also. You got district courts here, you got high court here. Go and attend the court and see how your seniors are performing, and that will be, I think, a great learning. The problem with the system under which we studied was that the first day when you go to court, you even don't know on which side you have to stand. Whether the petitioner stands on the right side or the petitioner has to stand on the left side. And the interesting part is that district court, high court and Supreme Court, 3 of them have got different system. Okay. In high court, the petitioner stands on the left. I'm talking about Delhi High Court. I think the same is in Chandigarh also. In district courts, the petitioner stands on the right. Similarly, in Supreme Court, the petitioner stands on the right. So sometimes, young lawyers, you tell them, he starts arguing, he tells them, you are for petitioner, I'm for the respondent. So you'll be standing on the side when the petitioner is. So if you go watch real courts in action, your seniors in action, at least those small mistakes you won't repeat. And the main problem that young lawyers are facing is now of drafting. Pleadings have become really very poor. The young lawyers are not paying the attention which should be paid to the pleadings. It's only a copy-paste thing which is there in the market right now. You want to file a suit for recovery, get a suit for recovery in e-form from one of your colleagues, just change the title, okay, and just file it in the court. Now it is for the judge to see whether that suit, whether para number 13 is the para relating to the present case or it relates to the other case. So we keep on pointing these things out. So even copy-paste is not a bad thing. Please do that, but before filing a case in court, at least you must devote half an hour going through it, the way we go through it, and I think you will be a successful lawyer. Thank you very much for being a patient audience.
Thank you, Lordship. Now we'll have Justice Meenakshi Mehta say a few words.
A very good evening to all of you. I thank the Chairman of Bar Council, Punjab and Haryana, and the members who gave me this opportunity to be here amongst you people and to share a few words with you. And not to preach here, please, and I won't take long also, because I know that Darwinian theory of evolution is working perfectly. You people are having better IQ, better awareness level, and you are better focused. You know what you have to do in your lives. So the only thing that I would like to share with you is that Almighty has bestowed each one of us with potential. Please don't keep your potential tight in a tight closed bottle. Open the lid and let it ooze out. You can do wonders. The only thing is that you have to realize the qualities and the potential that you are equipped with. You have to channelize it in the right direction. And please let me tell you one thing more. In every profession, if you are the first generation, you have to work hard. And there is no substitute for the hard work. You can't wish or claim that you can learn how to swim if you are on the bank of the river. You have to get into it. So the thing is that please don't take it to your heart if there is a struggling period in your profession. And one thing, there is an old Urdu couplet I would like to share with you, that is, गिरते हैं शह सवारी मैदाने जंग में, वो तिफल क्या गिरे जो घुटनों के बल चले. So Shah Sawar is here, the cavalier, the one who rides the horse and fights the battle in the battlefield. Maidane-Jang is, of course, the battlefield. So they say, गिरते हैं शह सवार ही मैदाने जंग में. Only the cavalier who dares to fight a battle and mounts the horse, he would fall. The thing is tifl. Tifl means a small baby. They say, वो तिफल क्या गिरे जो घुटनों के बल चले. So only a child would never dare to mount the horse and to fight the battle. He is just in the crawling stage. So if while fighting the battle, the cavalier falls off the horse, that doesn't mean that he has lost the battle. He has to again mount the horse and to fight. So please don't get disappointed, disheartened by the initial hiccups that you may face, and I think everybody has to face. Just take it as that God wants you to be a better person. Just take it like that. Failures are always lessons for a better, life, better version of yourself. Take it in your stride. If you are not successful in one attempt on one occasion, that doesn't mean that you don't have the potential. You have it, but still you are supposed to be more focused, and for that, introspection is a must. It's as necessary for your growth as the breathing is for a human being to survive. Spare out at least 5 or 7 minutes before you go to bed, after the din of the day. And just try to find out what good deeds you did throughout the day and where you earned. That can be the best lesson. You can teach yourself the best lessons from your own experiences. So please, whatever you do, whatever you choose to do in future, don't lose hopes. Don't get disappointed. Don't feel low. better vigor and zeal to, with the determination that I am bound to succeed and I have to succeed. So I won't take any more time because you are sitting here since long, so I will not keep you sitting glued to that chair anymore. So all the best to all of you, for students, for young lawyers. May all your dreams come true. Whatever you feel like doing, you should be able to do it. That's my only.
Thank you, Lordship. Now I invite Advocate Mayank to present the mementos to the esteemed guests.
Good evening, honorable judges and esteemed members of the bar and young promising lawyers. Now moving forward with our session, I would like to request the session coordinators to come up on the stage to present the mementos on behalf of Bar Council of Punjab and Haryana. Now I would request Mr. Advocate Chirag Mahajan to present the memento to Ms. Aruna Shaunbaug ma'am. Now I humbly request Advocate Abhishek Chaudhary to present the memento to Honorable Justice Mr. Talwant Singh. I humbly request Advocate Kritika Sagar Sharma to present the memento to Honorable Justice Meenakshi Mehta ma'am. Now I will hand over the dais to Ms. Vasundhara Asija, Advocate Punjab and Haryana High Court, for vote of thanks. Thank you.
I deeply am grateful that I could be a part of this seminar, and I've had a wonderful chance of interacting with Justice Meenakshi Mehta and Justice Talwant Singh on a personal level, and being a first generation female lawyer, I never thought I would get this opportunity in the first year of practice. So I recommend that you, if you're working towards something, just give it your 100% and you will get there. And from personal anecdotal memories, the last 2-3 days I've been coordinating with the sitting judges of Punjab and Haryana High Court, Justice Mehta and Justice Talwant Singh from the Delhi High Court. Every moment they've been asking me what is to be done, and they've prepared notes and researched more than we have done in the last 2 weeks. They've done it in the last 2-3 days. Even after so many years of standing at the bar and being at the bench for so long, they've still had that effort and jazba, jisko kehte hain, from inside. They felt that they want to encourage young lawyers. They took out time, and since morning they've been with us, attending all the sessions thoroughly. So I would like to thank you, Lordships, for giving us this precious time. And also, Aruna Shaunbaug ma'am for being here with us. And of course, the counsels, I would request them to just come here so I could introduce them as well. Because this could be you in a few years, and that of course could be you in a little longer time. So that is Advocate Amrita here. Eliza Gupta, Advocate Sally Gupta. And Supreet Gareva, Advocate Mahir Sood from AMS Genesis. I would also want to thank Indrajit Mehta sir, who accompanied Justice Mehta. I've appeared before you in the Raina Tribunal as well, so I've known him for quite a long time now. And I'm deeply grateful to Suvir Sidhu sir, who's the chairman of Bar Council Punjab and Haryana, for giving us this opportunity, to all the young students and young lawyers who could be a part of this program and make it a success. Hopefully it was. And also Lekhraj Sharma sir, who is the chairman of the Legal Education and Training Committee. So he handpicked us and kind of put us in the team. And we're grateful that we could be a part of this. So we experienced all of this. And I would also request that you guys, whenever you get a chance to visit the actual courts, see the proceedings, because this was a very toned down version, because it had to be presented in a very short duration for all of you students. So if you can actually visit the courts and see what happens, you must go. And I'm sure that you also would like to thank all the judges and the team that put a lot of effort to make this and of course euthanasia, as we've heard, as in 2011 the state was, it has gone on from there. There have been further judgments. So we're leaving this question in your minds to research and look upon what has to be done, what was done, what can be done, and at your end, what can you do to make it better. And we don't know if Aruna Shaunbaug got justice or not, but the Supreme Court, of course, gave that judgment. But you should look for the right questions and question the wrong answers. So I would like to leave you with that thought, and thank you so much all for being with us here.